Hello and welcome to today's session for MBL, the Landlord and Tenant Act 1954 renewal terms, and we're going to today be looking at case law and the lessons to be learned, and I'll try not to stutter that again. I'm Sarah Thompson-Copsey, and today, as I said, we're going to be looking at the Landlord and Tenant Act 1954 and particularly the issues around renewal terms. When we think about the 1954 Act, to the extent we do have to think about it, we're looking at leases that have security of tenure. That's where a tenant is in occupation for business purposes. And that security of tenure gives the tenant the right to a new lease on the expiry of its current lease. And when we think about the terms of that new lease, I think probably all of us tend to think in terms of, same terms and conditions as the old lease, save for an open market rent. But we do actually know that that's not quite true. It's not quite the same terms and conditions as the old lease. We all have at the back of our mind this idea that the tenant or the landlord may be able to change the terms of the lease, but it ain't easy to do so, is what we sort of remember. And if your client does want a change in the lease, it's important to remember that the old lease is not set in stone. It's not a permanent form of lease. It is possible to change it.